Stop scrolling because what I'm about to tell you in the next few minutes could directly affect your visa, your green card, your work permit, or even whether you stay in this country. These are not rumors. These are not political opinions. These are real documented changes happening right now. And most people don't even know the full picture yet. If you have any immigration status, any pending application, or anyone you love who does, you cannot afford to miss a single word of what comes next. I've spent years tracking every shift in U.S. immigration policy. And I'll be completely honest with you, what's happening right now is unlike anything I've seen in a very long time. The changes are coming fast. They're hitting multiple systems at once. And if you're not informed, you could make a decision today that seriously hurts your future in this country. So, here's what we're going to cover. The sweeping executive actions reshaping visa processing and travel, and the quiet but devastating changes hitting employment-based green card applicants. What's happening to H-1B OPT and work authorization holders? The deportation policy shifts that are creating fear even among people with legal status, and perhaps most importantly, what you should actually do right now to protect yourself. Stay with me because the most critical part of this video comes near the end, and it could save you from a mistake that can't be undone. Let's start with the big picture, because to understand what's changing, you first have to understand the strategy behind it. The current administration isn't approaching immigration as a series of individual policies. It's treating the entire immigration system as a machine to be rebuilt from the ground up. Executive orders, agency level, directives, and reinterpretations of existing law are all being used simultaneously. That combination is what makes this moment so different and so consequential. The first major shift you need to understand is what's happening at the consular level. The place where visas actually get approved or denied before you ever step on a plane. In recent months, visa interview wait times at U.S. embassies have shifted dramatically in certain regions. Some countries are seeing faster processing as diplomatic priorities change, but others, particularly in parts of South Asia, the Middle East, and Sub-Saharan Africa, are experiencing new administrative processing holds that can last months with no explanation and no appeal process. If you're waiting for a visa appointment or you're stuck in administrative processing right now, this is not just a backlog problem. This is a policy environment problem. And knowing the difference changes how you respond. Now here's where it gets more alarming. The administration has expanded the use of what's called visa revocation, a power that allows the State Department to cancel a valid visa even after it's been issued. This has always existed as a tool, but its use is accelerating. People have had visas revoked while traveling while in transit at airports, and in some cases without ever being notified until they tried to re-enter the United States. The legal basis being cited: national security and public interest, two categories broad enough to apply to almost anyone. If you have a valid visa right now, that is not the same guarantee it was 2 years ago. Keep that in mind. Let me shift to something that's affecting hundreds of thousands of skilled workers and their families: the employment-based green card system. This is where the policy changes are perhaps least covered, but most deeply felt. The administration has directed us is to apply stricter scrutiny to I-140 petitions, the foundational document of most employment-based green card cases. What that means in practice is that officers are re-examining cases that were previously approved, issuing requests for evidence on applications that would have sailed through in prior years, and in some cases issuing notices of intent to revoke, meaning they want to take back a previously approved petition. And here's the part that should concern you if you're on an H-1B waiting for your green card. The priority date cutoffs, which determine when you can actually file for adjustment of status, are not moving in a predictable direction anymore. The visa bulletin has become increasingly hard to read because the underlying demand data is being recalculated with new assumptions for Indian and Chinese nationals especially. The employment-based second and third preference categories remain decades backlogged, and new policy pressure on employer sponsorship is making some companies quietly reconsider whether they'll continue to sponsor cases at all. Stay with me here because I want to make sure you understand why this matters. Even if you think your case is secure, one of the hidden changes happening right now is a shift in how specialty occupation is being defined for H-1B purposes. The administration has not passed new legislation, but USUIs has quietly updated its internal adjudication guidelines to apply a more restrictive reading of what jobs qualify as specialty occupations. This means IT consulting roles, certain business analyst positions, and jobs where the degree requirement is considered flexible are being challenged at much higher rates. H-1B renewals, not just new petitions, renewals are being denied or sent requests for evidence at rates significantly higher than just a few years ago. If you're on an H-1B and your renewal is coming up in the next 6 to 12 months, please do not assume it's automatic. Talk to an immigration attorney before you file. The cost of that conversation is nothing compared to the cost of a denial. Now let's talk about optional practical training OPT and STEM OPT. This is the pathway that allows international students to work in the U.S. after graduation, and it has been a target of policy attention for years. There are currently active legal challenges to the STEM OPT extension program, and the administration has signaled that it views the program as an overstep of executive authority, which is deeply ironic given how it was created, but that's the political reality. If you're currently on OPT or STEM OPT, or if you're planning to apply, you need to understand that this authorization exists in a legally contested space right now. A court ruling which could come at any time could change your situation with very little notice. The administration has also made changes to the way I-20 documents and SEI's records are managed. There have been reports, and this is something we've been tracking closely at U.S. visa updates of SEI's terminations being triggered by minor administrative issues that would previously have been resolved quietly by the school. When SEIs gets terminated, your F1 status is technically voided. That means your OPT, your presence in the country, everything dependent on that status becomes legally precarious. If you are a student, maintain flawless records with your due. This is not the moment to be casual about paperwork. Let me pause here and tell you something that I think most channels won't say. The way immigration enforcement and immigration policy interact right now is creating a situation where people with technically legal status are still being caught in enforcement actions. I want to explain how that happens, because it is happening. The administration has dramatically expanded the definition of interior enforcement priorities. Previously, immigration enforcement inside the country was largely focused on people with criminal records or final orders of removal. Now, enforcement actions are being carried out against a much wider population, people with pending cases, people with expired but technically still active petitions, people in removal proceedings who had been given informal deferrals. All of these categories are now seeing increased enforcement activity, and the geographic scope has expanded to enforcement is no longer primarily concentrated in border regions. Operations are happening in major metropolitan areas, workplaces, and even near schools and churches locations that previously had informal protection policies. Here's the detail that most people don't realize. You can be in the United States with a pending application, technically authorized to be here, and still be detained if an officer makes a judgment call that your documentation is insufficient or questionable. This is not theoretical. Immigration attorneys across the country are reporting. Clients who were detained despite having valid work authorization or pending adjustment of status cases, the system is not making clean, careful distinctions right now. So, what about green card holders? Surely, if you have a green card, you're protected, right? This is one of the most dangerous misconceptions circulating right now. The administration has expanded the grounds on which lawful permanent residents can be placed in removal proceedings, public charge determinations, old minor criminal records that were never previously considered deportable offenses, technical violations in the original green card application process. All of these are being revisited. There are cases working through immigration courts right now where people who have been green card holders for 10, 15, even 20 years are facing deportation proceedings based on issues in their past that they believed were long resolved. If you are a green card holder and you have any question about anything in your immigration history, any prior visa violation, any arrest even without conviction, any use of public benefits, please consult with an immigration attorney before you travel internationally, because re-entering the U.S. as a green card holder is a moment when Customs and Border Protection can place you in secondary inspection, and the standard of review has shifted. Now let me come to something that I know many of you have been waiting for: the naturalization pathway. If you are eligible for U.S. citizenship and you've been putting it off, I want to speak to you directly. The distance between being a green card holder and being a U.S. citizen has never felt wider than it does right now. Citizens cannot be deported. Citizens cannot have their status revoked. Citizens travel freely. If you are eligible to naturalize and you have not filed yet, this is the single most protective thing you can do for yourself and your family. I understand there are reasons people delay cost time, emotional connection to their birth country's citizenship, but from a pure immigration safety standpoint, naturalizing is no longer a paperwork formality. It is a shield. The naturalization process itself has also changed subtly. The civics' interview is being conducted with greater rigor. The background check process has been extended, and there are new administrative requests being issued in naturalization cases involving travel patterns, tax history, and even social media activity. None of this means you shouldn't apply. It means you should apply with full preparation and ideally with professional guidance. Let me give you the 3 things you should do right now, regardless of your specific status. First, gather and organize every single immigration document you have. Every approval notice, every travel record, every I-94, every receipt notice. Keep digital and physical copies in multiple places if you are ever detained or questioned. Having organized documentation can make an enormous difference. Second, know your rights. Regardless of immigration status, you have constitutional rights. In the United States, you have the right to remain silent. You have the right to refuse a search without consent. You have the right to speak to an attorney before answering questions from immigration officers. Knowing this and actually using it when it matters are 2 different things. So, practice what you would say and do if that situation arose. Third, if your case has any complexity, any pending petition, any previous issue, invest in a consultation with a qualified immigration attorney now, not when something goes wrong. The landscape is changing faster than most people can track, and the cost of professional advice is a fraction of the cost of a mistake. I want to close with something honest. Immigration policy has always been political. It has always shifted with administrations. But what makes the current moment genuinely unusual is the speed, the breadth, and the use of administrative rather than legislative mechanisms to drive change. That means the rules can shift without Congress voting. It means a memo from an agency director can change how your case is adjudicated. And it means that what was true about your case 6 months ago may not be true today. That is exactly why a channel like us, Visa Updates, exists. We track these changes in real time. We translate policy language into plain English. We tell you what it means for real people in real situations. And we're not going to stop, because the need for accurate, trustworthy immigration information has never been greater. If this video gave you something valuable, a new understanding, an action you're going to take, a question you're now going to ask your attorney, please hit the like button. It takes 1 second and it helps this information reach more people who need it. Leave a comment below with your visa type or your situation. I read them, and the most common questions become future videos. And if you're not subscribed yet, subscribe right now, because the next video in this series is going to go even deeper into a specific change that almost no one is talking about. And it affects a category of visa holders that numbers in the millions. Your status, your future, your family. It's worth staying informed. I'll see you in the next one.